Considering the submissions advanced by learned counsel for parties and material on record, and particularly upon perusal of the impugned order, it is apparent that earlier, at the time of filing of revision, the revisional court had passed an interim order dated 2nd March, 2021, staying the proceedings pending under Rule 109 of the rules framed under the Act Staff. The next date fixed was 6th March, 2021, on which date the matter could not be heard and was actually thereafter heard on 9th March, 2021, when the impugned order has been passed stop. The impugned order merely states that the matter is ripe for final hearing and therefore, there is no occasion to hear the application for interim relief. Stop para. It is apparent that the Deputy Director of Consolidation has not at all adverted to the fact that earlier, at the time of entertaining the revision, an interim order had been passed staying the proceedings pending under Rule 109 of the rules framed under the Act Staff. It is also apparent that the interim order granted earlier has not been extended merely on the ground that the matter is ripe for final hearing. Staff. In the considered opinion of this court, it was incumbent upon the Deputy Director of Consolidation to have recorded a clear finding as to how continuation of the interim order granted earlier would be detrimental to opposite party, particularly when the effect of non-extension of interim order would be automatic vacation of interim order granted earlier. Stop. Discontinuing an interim order granted earlier cannot be merely because it was ex parte or that the case is ripe for final hearing. Stop para. Obviously, interim order must have been granted earlier to preserve the nature of disputed property, therefore, there should be some cogent reason recorded for vacation or non-extension of same. Stop para. It is also a relevant factor that the proceedings under Rule 109 of the rules framed under the Act were in the nature of execution pertaining to the order passed by the consolidation officer. Staff. Once the order passed by the consolidation officer himself was under challenge before the revisional court and the revisional court was seized of the matter, it was but natural to have stayed the operation of consequential proceedings pending under Rule 109 of the rules framed under the Act. Staff. The Deputy Director of Consolidation has not at all considered the consequences of non-extension of interim order granted earlier in the revision. Staff. Even otherwise, from the perusal of the impugned order, it is apparent that the Deputy Director of Consolidation has not at all applied his mind to the matter pertaining to extension of interim order. Stop para. Upon applicability of the aforesaid facts in the present circumstances, it is apparent that no cogent reasons whatsoever have been indicated by the Deputy Director of Consolidation for not extending the interim order granted earlier. Stop. As such, the order is clearly vitiated. Stop.